Item number 1 for orders.
May I please?
But he wants to say something.
I am appearing on behalf of Mr. T.J. Mandal also. As he is in bereaved membership, therefore little of accommodation I if
And what about the affidavit?
Well, he has submitted the affidavit, I believe.
It has come.
Whether it has come on the record, affidavit. On that very day.
Yes.
Mr. Kamal, have you looked into this additional affidavit?
Yes, Mala, a copy has been given to me, Mala. Affidavit, Mala.
We don't find any apology as regards the
Concerned officials.
concerned officials.
Only has given at para 5 he has written, I sincerely do offer my unconditional apology for the same and pray that the Honorable Court may accept my apology and drop the proceeding in this.
Because you see what we were thinking on that day
Yes, ma'am.
is, let us assume that X is a judicial officer,
Ma'am.
correct? There is some category statement made against him or some statement which is not up to the mark and affects the administration of justice. Definitely, you see, when we are taking up contempt, it is not for our orders.
Definitely.
So therefore, at least some solace to the officer who has been,
Plus to uphold the majesty of the court, Your Lordship,
Yes.
whosoever. That's undoubtedly true, ma'am.
the brother will elaborate.
Because what we see,
Yes, ma'am.
the apology, he has not done anything against us. What he has done
Against the officer.
is against the officer, making statements for which we have convicted him. But where is his apology against those officers?
No, last time there was a specific direction also from this Honorable Court, if I remember it, that he will go and apologize the officer.
That we have not asked him.
We are not asking him to go
That-
there.
He agreed. probably.
But whatever may be, that is another aspect of the matter. That is not what we have asked for.
Oh, sure.
What we have said,
But he has said,
that apology has to be to those officials by way of an affidavit before this court. But that is not, however, present out here. The apology is to us. He has not done anything to against us.
coordinate করে এখন ফাইল করবে kindly sir. Kindly sir.
Mr. Kamal, you have understood what we have.
Yes, sir.
So if you can explain it to him, he's already there. I hope he has understood. Mr. Goswami, you will understand.
আপনি এখন এফিডেভিটটো এই অফিসারদের পদস্থ হৈছে তেওঁলোককে এপোলজি আসল কৰিব লাগে কোৰ্টে তো খালি একচনে লৈ আসল এপোলজি আসল পাৰ্ডনিং টু
There are, Mr. Kumar, there are two judicial officers.
Yes.
One is the district judge without, even when he asked, he,
I know.
and the judicial officer concerned. At least the.
One is Polly Kolita, I believe. Huh? Polly Kotoke and the other one judicial session that's Robin Buchanan, Honorable Justice Robin Buchanan has now been elevated.
Not without giving the name, but you can give by designation that made a statement against honorable district judge. And it would be better if before filing the affidavit, if
we should let it.
if you are consulted.
Yeah, Mala will bet it. No, court wants.
No, you're a magistrate, it's okay,
Yes.
but that you see, these affidavit should be satisfactory, only for that purpose.
In fact, Lordship, since it was to be filed by him and was to come from him. I did
No,
not
that is
want
true.
to.
No, that is true.
Indulge
You
in-
see, as an amicus curiae, you are neutral. But we appreciate that.
Lordship,
But
I
the
will
fact
do
is
that,
that
Lordship.
if you look into it, that affidavit before he files it,
clear with that. So that one point affidavit will suffice the matter.
yes,
Apology to the concerned officers.
yes.
I'll coordinate with him and I'll do that, Lordship.
At a point.
So let that affidavit be filed, since Mr. Mahanta is in
Yes.
agreement, we are giving time. In the meantime,
In the meantime.
Lordship.
we'll take it up after view now,
Hmm.
because the Platinum Jubilee celebrations.
Hmm.
Uh,
Who is it?
20.
20. We are fixing it on 20 April.
No,
Uh, Mr. A. Barwan, and counsel appearing on behalf of Mr. T.J. Mahanta and a senior standing counsel for the High Court. Mr. Ziaul Kamar, Leonard, senior counsel. Amicus curiae in the matter, assisted by Mr. R.K.D. Chaudhary, Leonard, counsel. As well as Mr. Utpal Goswami, the respondent contemnor. Seen the additional affidavit filed by the respondent contemnor on 27/3/2023. So in the said context, the respondent is to allow him to file a further additional affidavit to bring on record his apology towards the concerned judicial officers. So the said prayer is considered and allowed. The additional affidavit shall be filed prior to the next date of, at least 2 days prior to the next date of listing. List on 24/2023. Or then we'll fix it on 21st.
yes. As you know, because 24 is a holiday matter.
No, 21st, because we are giving 2 days time.
Yeah, no issue. 21st.
He can file it by 19th.
Yes, sure. 21st date is the fixed, and 19 by 19 we will have to file it.
Because that can be settled by
We'll do like this. huh?
settled by today also, you can file it, but
No, it's not to be in a hurry, matter to it's an order to since your lordship has incorporated for what the affidavit is to be filed, if a copy is given to us, we'll incorporate those.
Mr. Counsel, you kindly get it from the nowadays. It is
No, yes.
Why do you need a copy for that?
No, right. We'll take out.
And Mr. Kamar, we have appointed you as both of you as an amicus.
Right, ma'am.
Only for the purpose that as there is already a counsel out there.
Yeah, right.
And he may not, we'd like to hear a neutral.
No, sure, man.
So that is the reason where we have appointed.
Absolutely. True, man.
yes, wait. Yes.
It is a lordship. Lordship, I beg to mention item number 3 of today's list, your lordship.
Yes.
May I please the matter may come up next week, your lordship.
Wait, next week doesn't come. This matter is being adjourned. Just on item 3. You see, the reason is that there is an interim order operating. Correct. So every process has been stalled. So so therefore you take an interim order and then conveniently you adjourn the matter from 2018 to 23. That can't be allowed.
Lordship, on the last occasion when the matter came on 24th of February, it came up in the orders column, Lordship, because service was not complete, Lordship, response number 5, Lordship.
No, it's okay, but you see, 2018, there is an interim order operating. I'll make it clear that if on the next day prayer for adjournment is made, then we'll vacate the interim order. Both sides are represented on the prayer made by Mr.
And Gautam, your Lordship.
N.
Gautam, your Lordship.
Gautam, Learned Counsel for the petitioner, the matter stands adjourned today. It is noted that interim order is operating since 4/4/2018. Hence, it is provided that if on the next date the Learned Counsel for the petitioner is not ready for arguing the matter, comma, the interim order shall be vacated. As the readings are exchanged. Court is inclined to issue rule returnable forthwith without requiring the petitioner to take fresh steps. This is the matter for hearing on 2/5/2023. Yes. Switch on the speaker.
My lord,
Yes.
I beg to mention item 8, 9, 10, and 11, my lord. My senior is having some personal difficulties for today, my lord. Let the matter be-
2014 matter, I'm not going to adjourn for any reason.
We have taken the.
No, you may assist me, you may not assist me, but 2014 matter, I'm not adjourning. No, refused.
Okay.
If 2014 matter you are adjourning, you be prepared to pay 2 lakh rupees as cost. If you are ready, take an adjournment.
I will inform the senior, my lord. Okay.
No, way matter will be adjourned.
May I please your lordship, lordship, I beg to mention item number 4, lordship. Then the matter will be adjourned for 1 week, lordship.
Okay, list after. It goes after view. List after view. A question is paid for by line counsel with the petition.
Yes,
Four.
obliged.
You are there?
Yes, my lord, I'm for the private respondent number 3, my lord, 13, my lord, in this case, my lord.
Okay, both sides are represented.
Obliged.
Obliged.
Daily list, item number 1, motion BF.
Let resolve, lordship. No, these are
Yes.
earlier rejected by lordship, lordship find case 49, my lord. That order was passed on, my lord, case 50, my lord, on 25/7/2022, my lord. And at that point of
Page-
time, my lord,
Page 49.
case 49, my lord. And case 50, lordship find it was rejected on 25/7/22, my lord. And case 53, my lord, Lordship's observation, my lord. 9 and 10, my lord. Para 9, 10 and 12. So
Okay, what is the stage of trial now?
now, my lord, we have annexed around 7 witnesses, my lord. Out of 26 witnesses, my lord, 7 and those are most vital, my lord, because the father of the deceased, my lord, and the other kidnapped persons, my lord, the injured witness, my lord, they have been examined and their
Mr. Bulwa, we
deposition-
are issuing a notice. We prepared to argue the matter on Monday.
My lord, in this case, Lordship, the scan copy will be referred.
We have
It is there
annexed-
in the other, in the earlier it was there.
My lord.
I think that will be available.
My lord, let me on Tuesday, Lordship.
And the deposition we have annexed, my lord. It starts from page 36. my lord. Evidence before the court, my lord.
It is there. List the matter on, give it on Monday,
3, 4.
along with. Stop. Let the records of BA 1497 of 2022 containing scanned copy of the case records be tagged along with. This was a voluminous diary. Okay, list on switch.
We may go through the
We
deposition.
will give you the scan copy. It was voluminous. It was there in the earlier, earlier round.
I'll note. Lordship.
And he can go through the evidence also. We have annexed, my lord.
You see that?
Because
Fine.
evidence, my
Evidence
lord,
also.
they did not say anything, my lord. That would be important possibly.
Okay. Nobody goes to say anything against people who are
That's,
DHD kidnapping,
no, lordship, that's why their bill were rejected, my lord. Now.
that
my
is
lord, they were
okay. But we don't expect people to come out and give statements against the banned organizations.
My lord, they are inside, my lord, for around more than a year, my lord. And my lord, already the vital witnesses examined, my lord. There is no question of hampering or tempering or influencing them, my lord. You already their statement taken, my lord. That is,
It's okay, just
that's why, my lord.
go through it.
Yes, my lord. Obliged, my lord.
2 for admission.
Wait, please.
Kindly pass over whatever timing.
This matter.
Stay over will, is on his way, my lord.
On that day, your lordship, Mr. Fukan
Mr.
was not
PJ
there.
Fukan, no, Mr. Fukan is there now.
He's there.
He was on leave.
Yeah, he is, today he's there.
Mhm.
So,
Okay,
My lord. Timing. my lord.
okay. We can start hearing him.
yes.
We can start hearing him.
Yes, sir.
You'll be there.
Yes, my lord.
So this matter, your lordship, basically we are challenging the appointment selection and appointment of principal of Dibru College, Dibrugarh. I'll just go, first I'll come into the advertisement and second part I'll come into the different aspects of these qualifications of the petition. Lordship, we'll start with the advertisement, that is on 1/12/2017. Your lordship will find it at page 28. Here only, we are concerned with one part. So advertisement is page
Advertisement
28,
dated 1/12/17.
1/12/2017. This is the type copy, the original is at page 30. 1/12/2017. So applications, I'll just read 2 paragraphs. Applications are invited with complete biodata and supporting testimonials from SSLC onwards for the post of principal Dibru College, Dibrugarh against regular vacancy in pursuance to DHE's order dated so and so. From intending candidates to proper channel, having qualification, experience, norms, etc. as prescribed government guidelines given below. Master degree with at least 55% marks or equivalent grade in point scale wherever Grading system is followed by recognized university. PhD degree in concerned allied relevant discipline in the institution concerned with evidence of published work and research guidance. Here, the issue is research guidance. So the rest are associate professor with total 15 years experience. These are others have been complied with. Only issue is the paragraph 2, that is research guidance. My allegation, specific allegation in this case, only one allegation, that the person does not have the eligibility because he does not have research guidance. The
Right.
selected one is the respondent number, your lordship. Respondent number 6. Now, your lordship, we kindly turn to page 32. This I'm pointing out on 2 grounds. First is that the selection and eligibility has been considered in this particular committee meeting. That is at page 32. Modification of report of committee constituted by Honorable Vice Chancellor and Chairperson of the Selection Committee for selection of Principal of Dibru College, Dibrugarh. The first part, your lordship, is that the Honorable Vice Chancellor of Dibrugarh University Chairperson Selection Committee has recommended of candidates to be considered for appointment as Principal at Dibru College as per order of Governor Assam dated 9th November 2017 and communicated to the Principal Secretary Dr. Assam Higher Education, which was notified by DHE dated 12/12/2017, constituted a committee to screen the applications of candidates who applied to the post of principal of the said college as per the advertisement dated 1/12/2017. So this is screening. The committee screened the applications as per the rules and norms of UGC. This is important, as per the rules and norms of UGC. And State Government of Assam on 5th January 2018 and re-scrutinized the API of one of the candidates on his prayer on technical ground, and as forwarded by the member secretary of the selection committee for principal and president of GB of the Dibru College on 9th January 2000 with approval of the Honorable Vice Chancellor. After verifying the norms and API as per guidelines of UGC and state government of 4 applicants, the committee has found that all candidates have fulfilled the requisite API score to be called for interview. 1, Dr. Taranath Jitu Buragohain is the respondent number 6 and Komolendu Soikia is the petitioner hearing. Both were found to be eligible as per the guidelines of UGC and API norms. I have pointed out because I'll come to the next part later on. So both were found to be eligible. Now, your lordship, my issue is that in fact, thereafter, your lordship, there is an additional affidavit filed by us. That is, in the additional affidavit, I have annexed in annexure N, page 5. Kindly take the additional affidavit because this was subsequent to the filing of the writ petition. On 31/2018, page 5 of the additional affidavit. The respondent number 6 have been appointed. We came prior to the appointment, but in the meanwhile, the appointment was done. So I brought it before this on report. So this is also on the challenge. The appointment was done on 31/2018. So I filed the representation initially, that is at page 38. I'm not reading that. The issue that I raised was that the respondent number 6 is not qualified to be appointed on the ground that he does not have the requisite qualification of research guidance. In fact, I have given annexure L at page 35. List of recognized PhD supervisors in various departments of affiliated college under Dibrugarh University. I have given the names of all these persons. That is at page 35. It is the list. This list, your lordship, I'm not reading that. Here in this list, the name of the respondent number. This is Arts, Commerce and Science. three different streams. So in the, all the three streams, the name of the respondent number 6 is not found. He is not there. There are, in the arts, page 35 is arts, 36 commerce, and 37 is science. In all the three streams, the name of the respondent number 6 is not there. So he is not a recognized PhD supervisor in any of the affiliated colleges under the Dibrugarh University, which he has stated to be. And he was called for the interview. Now your lordship will kindly take up the affidavit in opposition. This is basically my case. If your lordship will kindly take up the affidavit filed by the respondent number 2, the director. Now, my question was specific. Your lordship notes that there was no, he was not a research guide under the research guideship is not there. That is my specific allegation. Therefore, he is not entitled to be selected under the UGC norms. But the affidavit does not touch that. I will read what they actually started bringing in certain allegations against me. So your lordship will kindly take up the affidavit for a moment. Page 2 of the affidavit, paragraph 4. This issue was brought in. Paragraph 4, page 2 of the affidavit filed by respondent number 2. The deponent begs to state that petitioner is working as associate professor in Dibrugarh College. As per submitted records, the petitioner was recognized as guide for research under the Periyar Institute of Distance Education under the Periyar University, Tamil Nadu, in distance mode, and also recognized as guide by the Vinayak Mission University, Salim, for the MPhil degree. Then, your lordship, they have come to paragraph 6. Your lordship. The deponent begs to state that the petitioner appeared in the interview for the post of principal on so and so, along with other candidates. The members of the selection committee awarded marks to the candidates as shown below. The respondent number 6 is at serial number 1 and myself at serial number 2. So there is a big difference in marks. I am not on that because obviously the eligibility is not there. So that comes subsequently. What marks he will not get, that will be separately. This comes later. Now your lordship will come to para 8 at page 4. This is important. The deponent begs to state that the petitioner has submitted a complaint petition dated so and so stating that as per university norms, any teacher of a college having research guideship for himself, he must be a teacher from postgraduate department of a college as well as Dr. So and so, principal Namrup College, neither a teacher from postgraduate department nor a principal of postgraduate college. The claim of the petitioner is not tenable as it is not necessary that a research supervisor has to be from a PG level institution. The selected candidate is a research supervisor of Dibrugarh University. Now, I have given the list of supervisors of Dibrugarh University. His name is not there. They did not, just making a vague, your lordship, wrong statement here, your lordship. Now, your lordship, in para 10, this is important because that is where they are harping against me. Para 10. That the answering deponent begs to submit that the petitioner does not fulfill the criteria laid down in UGC Regulation 2009 as per the provision made in University Grants Commission. So and so regulation. A university cannot hire the service of a faculty member of any college teacher or university teachers of another university to be appointed as research guide for MPhil PhD programmer. If any university is practicing the same, it shall be against the UGC Regulation 2009. The clauses 6.7.8 and 12 of the regulation are quoted below. They've quoted these two regulations, 6 and 12. All university institutions deemed to be university and college institution of national importance lay down the criteria for faculty of recognized as a research supervisor for both PhD and MPhil and PhD programs. 7, all university institutions deemed to be university, college institution of national importance shall lay down the decide on annual basis a predetermined and manageable number of MPhil doctorate students, depending on the number of available eligible faculty supervisors. Supervisors shall not have any point of time more than 8 PhD scholars and 5 MPhil scholars. So this is there enclosed. Now, basically, these are the points on which they have given their response to my petition, writ petition. So they have not stated, they have stated that he is the respondent number 6 is a research guy. But from where? They've stated he is from the Dibrugarh University. I have annexed the document. Now your lordship will take up my reply, affidavit in reply. Here, your lordship, I have annexed 2 documents, para 7 for a moment, your lordship, page 4 of my additional affidavit, reply affidavit. With regard to the statement made in para 9 of the
Just a
affidavit.
moment.
Yes. Paragraph 7 at page 4 of the affidavit.
Which affidavit? Which
My
affidavit?
affidavit in reply. That was filed on 28/4/2023.
Yes.
Here at page 4, your lordship, para 7. That with regard to the statement made in para 9 of the affidavit in opposition, the deponent begs to state that the petitioner was a recognized guide under the Perrier Institute of Distance Education, Perrier University, whose guideship was approved on 15/6/2007. This date is important here. Because why I'm saying, because the order or the regulation which came in 2009. So at that point of time, in 2007, these are all recognized. In 2009, subsequent thereafter, it has not been recognized. So at that point of time, Perrier University as well as the other Vinayak University were recognized. So that is why I'm giving that particular dates here.
Please
Also,
repeat that again.
Lordship,
Please repeat that again. After, why this date is relevant?
relevant because they have alleged that after 2009, a person from particular university cannot be a research guide of a different university. So here I am a research guide of Perrier University and Vinayak University. Both are outside the state of Assam. They have annexed a document. I'll come to that documents also. I have also annexed that, where the state of Assam has said that under the UGC regulations 2009, on the basis of UGC regulations 2009, the person will not be eligible if he is a research guide of a different university, not the university, in concerned university of the state. So that is the issue. Therefore, they pointed out that I am not eligible, though in the eligibility criteria I was selected. That I will come to later on. So here, your lordship, the 2 universities they are showing. So I am reading this paragraph. Recognized guide under the Perrier University, whose guideship was approved in 15/6/2007. Also, the petitioner was a recognized guide under the Vinayak Mission University with effect from 16/10/2007. The petitioner has guided candidates for MPhil degree which are under the said universities in 2008 and 9 itself. The office memorandum dated 9/7/2012 have indicated that off-campus, this also is important. Office memorandum dated 9/7/2012. This is the memorandum of the state of Assam. Have indicated that off-campus study centers which are in existence in the state is violation of Honorable Supreme Court's order, do not function, and the government of Assam will not recognize any degree diploma from such off-campus centers. Fine. Degree diploma from the off-campus centers after 2012, they cannot. Already these people which we have guided in 2008, 7, 8, they've already got jobs. There was no, there's nothing to do with that. That nothing to do with my eligibility also. After 2012, some people getting degree diploma from these type of institutes, they are not recognizing it. We are not challenging that. Fine, that is nothing to do with my case. So your lordship will kindly turn to page 8 of that particular affidavit in reply. Your lordship. This is the office memo. This is date. That is why I was saying the date is important. This is in 2012, your lordship, 9 July 2012. Now here they have said that with regard to the Honorable Supreme Court case of Professor Yaspal and others versus State of Chhattisgarh, no university can start off-campus centers beyond their territorial jurisdiction of the concerned university. So this was done in 2012. They have decided in Assam that off-campus will not be done. Fine, we are not on that. At 2007, I was there, maybe off-campus. Those were at that point of time, it was, I'm eligible. They have selected me and for the meeting of this screening committee, they found me eligible with these particular documents or these guides. Everything was fine. Now they cannot put it up. 2012, it's not a retrospective order, your lordship, notification or office memorandum. It cannot be known. So UGC guidelines permitted that up to 2009. Government of Assam says they off campus in 2012. Both are prospective in nature. So I am eligible. Eligibility part they cannot question. The only issue that requires to be answered by them was whether the respondent number 6 was a qualified guide, research guide. He was a research guide or not. That was the simple question. They should have, as per the annexes that I have given, he is not a research guide under the Dibrugarh University. So they have not given any documents to show that he was a guide from any other university or whatever else.
So that is the only point.
That is the only point. They have not made that. It's not answered that. Now, your lordship, I'll finally point out one more thing. Page 11 of my affidavit in reply. Same affidavit. Here I am bringing in because I want to point out two things. This is a list of colleges, principals of colleges, various colleges of Assam, all over Assam. There are about 48 colleges. All these colleges, your lordship will see name of principal, name of the college, principal, so and so, so and so, so and so. Now your lordship will go to number 7 or serial number 7. Mankacha College, so and so is the principal. See the guide sheet from. Kindly see the guide sheet. Vinayak Mission University. So there are principals who were appointed at that point of time, who are also from, and the next one at A is Periyar University. See, next Periyar University, serial number 8. Someone Singardia University. Again, serial 13 is Vinayak Mission University. So it is not a fact that at that point of time, those who have been guideship under the other universities were not principals of any colleges. That was not done. This is also I have given by in my affidavit, bringing these into record.
During our times when we were students,
Yes.
it was one of the best colleges was BH College only.
Yes. So it had a name.
Cotton College.
BH College at that point of time, lots of persons-
Cotton College and Durham College.
Durham College.
Three
Durham
colleges,
College.
Lordship, and JB College of Jorhat, Lordship. 4 colleges.
JV College.
I don't remember.
Then,
I don't remember, but
Kanoi College, even Kanoi College, Dibrugarh was from where I studied. It was also a good college.
After Cotton College, we had BH College and Durham College.
no, it was Kanoi College, yes.
No,
I
Kanoi
remember.
BH
that
is
college.
Kanoi College from Dibrugarh.
Hmm.
I was alumni of that college. Anyway, that was also a well-known college at that. Anyway, we are not on that. But
Okay.
these are the facts that I am citing. Now, only I will not point out the judgment as of now. Let them answer on these facts. There
No,
are
you give your judgment because he'll be able to
Yeah.
just give the citations at least.
Yes, these three judgments on 3 points, your lordship. First is that 2009, I'll give the judgments, your lordship. First, 2009, 4 SCC, 590. This is Annamala University case. This is a famous case, your lordship. I think my learned friends also know about. Here, your lordship, the
He has memorized it.
very long old case, 2009 case. Here, your lordship, the court has specifically indicated both the things are required in this case. First is that the UGC regulation have to be followed. You cannot bypass the UGC regulation by any other rule or office memorandum, whatever it is, you cannot bypass it. Here it was with regard to two cases. There was the IGNOU, your lordship knows Indira Gandhi Open University. There was a challenge between the two acts, whether which will prevail. Ultimately, it was said that the UGC Act will prevail, even though IGNOU has their own act, but that will not, where there is a clash between two acts, then the UGC will prevail, because the UGC norm will have to be followed by even IGNOU also. So here the court says two things. First is that UGC qualifications and given in the UGC Act are must and have to be followed, which is one of my criteria here, because in this case also I am saying that he is not eligible as per the UGC norm. Second part is that here that talking about IGNOU and other universities, which are, your lordship, these universities actually do not provide education in their campus, off campus. So it says that off campus PhDs and other MPhils of off campus are also equivalent to the normal colleges. That is said by this, and subsequently the other judgment, that is 2018, your lordship, we kindly
That
go
is,
down.
that is with the qualification.
That is on
There without, it should be in campus, not off campus.
not off campus, but here it is said that qualifications of UGC must in off campus, on campus, all. And second, it says that the degrees and PhDs and the other degrees, MPhils provided by the off campus as well as the on campus cannot be said to be unequal. It has to be equal. That is also there. That is why this is, your lordship will take up para I am giving para 40, 41 and 42. I'll read it later if your lordship requests. Then this has been followed in the next case, that is, your lordship will find 2018 16 SCC page 533. This is, your lordship, here the court has considered the case of Annamalai University 2009 and have in para 12 has said that he actually took up another judgment which said that Annamalai University judgment is the correct judgment. So that has been given here, and these 4 paragraphs, that 3 paragraphs have been quoted here in paragraph 12 and 12, your lordship, and 14. And here in para 14 it says, that is why I was saying, in view of the observations in Annamalai University and the above directive, we are of the view that as a consequence, PhD degree issued by an open university and another PhD degree by formal conventional university must therefore be treated on par, having been issued under the uniform standards prescribed by the UGC. Therefore, this has been the conclusion. So these are the 2 judgments that I am placing at the moment, your lordship. It covers both my points of this case.
Yes, Mr. Gogoi.
Lordship, after going further submission made by my senior brother, Lordship, the moot question my lord have to consider whether the person respondent, Lordship, has qualified the UGC criteria or not, whether he is the required research guideship or not, Lordship. Only question, Lordship, is to determine whether he is a valid research guide or not, Lordship.
No, that, you see, that last time also I said. You see, number one, there are 2 ways to visit this, this point which you have raised. Number one, this is a writ petition by the petitioner.
Lordship.
Inquiry against him is not desirable.
Lordship, no, I am not saying against him, Lordship. We have to, Lordship, have to decide the things, Lordship, whether the respondent, which was appointed as a principal, has a research guide or not, Lordship.
Yes.
Only that part my lord
Yes,
have to
yes.
decide, Lordship.
Yes, yes.
Other things, Lordship, I ignore, Lordship, because other things we have not placed before Honorable Court. Just one question, Lordship has to decide whether he is a research guide or not, Lordship.
Yes.
I have the records, Lordship. Before the Lordship, the interview was held on 2015 itself, Lordship, and 18 itself, Lordship, and appointment appointment to Lordship. Lordship, appointment was made, Lordship, on 31 2018, Lordship. It's a additional affidavit filed by my senior brother, Lordship. Additional affidavit in page 5, internal page 5, annexure N, Lordship.
Yes, 30,
Annexure N, it was issued on 31 2018, Lordship, for a period of 5 years, Lordship.
yes,
It is a terms appointment for a period of 5 years span,
that
Lordship.
has gone.
And that part is already gone, Lordship. Now, Lordship, my lord have decided whether the particular decision taken by the government of Assam was right or wrong, Lordship. Whether that person was holding the post of principals by right way or wrong way. That's, Lordship. My lord may kindly peruse the records, Lordship. I have passed over the records, Lordship. Records reflect that, Lordship. I will hand over, Lordship. It is a letter issued by the Register of Debuga University 26/4/2012, Lordship. It is stated that I would like to inform you that your application on the subject cited above was placed in the meeting Research Council of Science held on 4/4/2012. As per the decision of the council, you are now considered eligible supervisor of PhD works in Debuga University, Lordship. It's a certificate 26/4/2012 issued by the a competent authority of the Debuga University, which says that Lordship is a research guide of the Debuga University. And Lordship, another annexure is also here, Lordship. That is a notification issued by the Debuga University for awarding of PhD, Lordship. In CL number 20, it's reflected that particular respondent number is a research guide of Hiramani Das, Lordship, Life Science, and she was awarded PhD on 16/2015, Lordship. My lord may kindly peruse only 2 documents. Dada, itu video tu. Only 2 flag marks. First one is, Lordship, regarding
But,
research, Lordship,
but you see, ideally, Mr. Gogoi,
Lordship.
this document you'll have to bring on record because the petitioner may like to controvert it.
Lordship is a part of the record. After calling the record, we have bring it, Lordship, from the authority, Lordship. So,
The record was called for.
oh, no, Lordship, record was called for, Lordship. The record was called for, Lordship, on 5/2/2018, Lordship, when notice was issued, Lordship. At that very day, Lordship, record was called, Lordship, 5/2/2018, Lordship.
No, but then you see, I have my own reservations. Number one,
Lordship.
you change yourself from the counsel for the respondent and become a counsel for the petitioner for time being.
Lordship,
Correct.
Lordship,
You are arguing a matter
Lordship.
and then suddenly some record comes which is against you and you don't know how to meet it. You see, there is a reason for that.
Lordship.
Number one, Mr. Manan has pointed out that he made a specific allegation in his in para 10. Para 10 is not controverted,
Lordship.
correct? So without controverting that, you are bringing a record which says there's something else. Now, again, there's another way to look at it.
Lordship.
Unless you controvert in your affidavit that he has that that the statement made in para 10 is false.
Lordship.
Otherwise, the petitioner is not prepared to argue the matter because he'll be taken off guard.
Even, Lordship, we have stated in our paragraph that, Lordship, the PT respondent has the valid research guide, Lordship. We have stated, Lordship, in our affidavit, Lordship.
Shows that. Shows that. Because Parava's reply is not there.
Lordship. And honorable courts call for the records in 2018 itself, Lordship, 5/2/2018, Lordship.
But then you see this affidavit in opposition is filed in 2022. Why this document will not be there then? If the records are with you. Whether Mr. Manan wins the case or you win the case is not
Lordship, it
not
is not a fact,
relevant.
Lordship. I am not saying that,
No,
Lordship.
not, you see,
Lordship.
please try to understand. It is
Lordship,
a
Lordship.
contested litigation.
Lordship,
Whether Mr. Manan wins or you win is immaterial. But we have to have clarity in the manner in which one has the notice of what is coming.
see, our duty is to, Lordship, not to win the case, not to lose the case. Our duty is to, Lordship, assist the court by
that
proper
is-
way, by placing the document from the
That
government
is
side.
true,
Lordship.
that is true. But you see,
Government
this,
side, Lordship.
that is true. That is why an
If,
affidavit has
Lordship,
to be there.
anything wrong by the government, we cannot support it, Lordship.
No, I'm not saying that.
Lordship.
Did I accuse you of anything?
Yes.
But the fact is that if a document is
Yes.
there showing that he's a research guide, that is, the petitioner should know it.
They should have at least written in their affidavit saying that he was a research guide by this letter dated so and so. I don't know the letter anyway.
Because he would, which paragraph, Mr. Gogoi?
Lordship. Lordship, paragraph 8. Paragraph 8 of our affidavit, Lordship. Paragraph 8, we have stated that the deponent begs to state that petitioner has submitted a complaint petition dated 17/1/2018 stating that as per the Dibrugarh University norms, any teacher of the college having research guideship for himself, he must be a teacher from the postgraduate department of the college as well as Dr. Jitu Borgohain, principal of Namrup College, neither a teacher from the postgraduate department nor a principal of the postgraduate college. The claim of the petition is not tenable as it is not necessary that a research supervisor has to be from a PG level institution. The selected candidate, Dr. Jitu Borgohain, is a research supervisor from Dibrugarh University.
No, this. But then his name does not appear in the list produced by him.
Yes,
Lordship, that part, Lordship, I cannot say, but Lordship, the certificate of the register,
one
the
thing,
competent
Your
authority of the
Lordship,
Dibrugarh University, Lordship,
I'm-
as well as the notification issued by the Dibrugarh University where PhD was awarded in serial number 23. Lordship, his name is reflected as the supervisor. Whether that is a, Lordship, fake document or genuine document, I cannot say. This was issued by the Dibrugarh University, Lordship.
76. His name is Jitu Borgohain.
Lordship,
Jitu
serial
Borgohain.
number 23, Lordship, is a research guide of one particular person's, Lordship, awarded PhD, Lordship, 2015.
This is an advertisement was of which date?
Lordship, advertisement was 2018, Lordship, 18. 1/12/2017, Lordship. 1/12/2017, Lordship, page 30 of the writ petition annexure H, Lordship.
one more thing, Your Lordship, whether that particular Dr. Jitu Borgohain is from which department?
He was then the head Department of Botany, Namrup College. And he was a guide for Hiramani Das of Life Sciences.
Lordships, the annexure 35, Lordship, annexure L, kindly peruse, Lordship. It is a from a humanitarian group, Lordship. It is not a, Lordship, science department, Lordship.
Page.
The
25.
list which was annexed, Lordship,
Just a moment,
in page 35, Lordship.
just a moment.
This is arts. Arts. Science to what? 37.
35
Science
is
is
arts.
37, Lordship. In
37
life,
is science here.
science is 37, Lordship. And the date was not there, Lordship, when it was issued, Lordship. No date, nothing is there, Lordship. And who have issued this particular documents, that is also not there. No seal signature, no university fee.
In their
Nothing is there,
affidavit in opposition, what they have said with regard to this paragraph. Your Lordship.
No, there is no Parav's comment is not made. Parav's reply is not there.
Here the list submitted by the petitioner, Lordship. It was who has issued this particular list, Lordship. That is not reflected from the particular document, Lordship. It is not under the seal and signature of the Dibrugarh University, Lordship, authority of the Dibrugarh University, Lordship.
Mr. Pugan appears for respondent number 6. He does not respond at all.
Lordship, it is his part, Lordship. Our part is we on the basis of the records, we have to argue, Lordship. We have to place the proper text before the honorable court, Lordship.
Because if he shies away, respondent number 6 shies away from responding, that would be heavily against him.
It's his duty to point out and our duty is to point out on the basis of the record, Lordship.
The case is already based on the records here, so may not.
No, but you don't respond to it. You admit that you are not a supervisor because you don't controvert anything.
Since the records and the affidavit of the government is clear regarding that aspect, regarding that research. Regarding research guides, the affidavit of the government, it is clear.
You cannot ride on others. You don't take a stand.
My lord, one pertinent aspect of the matter, my lord. The 5 years term, it is over in January 2023, my lord. And the respondent number 6 is going to return on 31st March. A new advertisement was published on 4th of March.
No, but
2023.
you were appointed when?
My lord,
You were appointed on 30 January
no, my lord.
30
January.
2018. So you should have gone by now. How can you be there in 2 months' time?
As per my instruction, yes.
Lord,
Continue as per my instruction.
Director of Higher
I don't know under
Education.
what circumstances that has not been given.
Director of Higher Education's order was issued on 30th January 2018. And the respondent number 6 joined as principal of Dibru College on 3 February 2018. So from 3 February 2018, within 5
No,
years,
it's not a joining on pleasure. 5 years means from the date of appointment, it should be.
a date
Even
of joining.
if your lordship joining is taken into consideration, it will be on 2nd of February. He's the last.
The
So I don't
order
know
of
how he's continuing
the-
beyond.
the order of the Director of Higher Education, my lord. Terms and condition, clause 4. The term of appointment is 5 years from the date of joining.
From the date of joining, okay.
After 5 years, the person shall have to appear before selection committee as notified by government director of higher education. During the 5-year period, the base post of the incumbent will be kept vacant so that in the event of non-selection, he can revert back to his base post. That means Namrup College, my lord. He was serving as principal of Namrup College. The college will not advertise the base post held by Dr. Jitu Burago. So, my lord, 5 years from the date of joining. So he joined on 3 February 2018. So on 2 February 2023, 5 years term is over. His term has been extended up to his retirement date, that is 31st March, this 1.5 months. And new advertisement was published in Dainik Janambhumi and Assam Tribune on 4th of March 2023. So Milord is only academic interest, Milord. It will serve academic purpose, Milord. Whether his research guides.
No, no, you don't expect that I will keep it pending till 31st. But you see, the non-traverse, that is something which is troubling me from your part. You don't even answer your disqualification. You serious allegation against your disqualification and you don't traverse. It is an
Okay.
implied admission.
In fact, I have prepared the affidavit, Milord. If the matter comes up as 2, Milord, and Milord.
No, no. There's always in a wall, there is always a space to put nail and hang it. Frame it and hang it. There's always a space in the wall.
Yeah, we used to, when we were in school, we used to put posters in our walls. Those heroes we would like. So we always have a space for one or the other. And in fact, Lordship has just stated that he was from botany. From botany, your Lordship said that the respondent 6 is from botany. One something has struck me. Now that PhD, your Lordship said, is from life science. So what happens is in such matters where it is out of different departments. So what happened? I am the guide of a particular candidate of a particular department. For example, from life science, I am the guide. Now what happens if something else required from some other department? So there is another person from the other department who is not the research guide, but is like a supervisor of this, because he will have to do some research work in the other department also for getting the guide signature. So in that case, he is not a guide, but just a supervisor in that. So then there is a difference between these. I don't know in what sense, because since your two departments are involved,
No,
I don't know
that-
how it has.
No, that you see that I may not agree with you. Number one, insofar as life science is concerned, life science is a combination of many streams.
Many- But I
It
think there is a
includes,
specific
it includes what you call human life,
zoology.
human life, zoology, botany.
Yes.
So anything which has got anything to do with study of cells
Zoology and
Is a
molecular
part of-
biology also included, Lordship.
is a part of life science.
Maybe, your lordship is right, but normally what happens if it is between two departments? Then the one department, the research guide is there. And the person who is required, the research person is required to take some.
No, this is something I personally know. That's why I'm
Because
telling
I
you.
personally also know because of my wife.
So life science, because
I
my
don't
son,
know how he it is.
my
but
son
that is
was a
up to
student
you.
of life science.
Because
this
life
one.
science include both. I think in
Any-
fact.
Any study of cells, it may be human, it may be
was not-
animal, or it may be what you call
Plants.
plants, anything. Yes, Mr. Fukan, how do you come out of this doctrine of non-traverse? Why it should not be read against you?
My lord, without finding the.
Since
equity
I,
position,
since
my
I
lord,
come from my school, which is behind civil court. So therefore, I remember that Roya Properties, where it says in connection with the non-traverse, it says that non-traverse amounts to admission under order 823.
My lord, for me, the only way out is to pray before your lordship. My lord, soft copy is with me, my lord, right at this moment. my
No,
lord,
this time we can't permit because we have already heard the matter.
my lord. Duly constituted selection committee, my lord, headed by the Vice Chancellor of Dibrugarh University, selected me, my lord. And with all the relevant documents, and the documents records are before your lordship.
I don't know, but I have seen you contesting against the vice chancellors.
And the other aspect, regarding that infractuous, aspect, that academic interest, since, the entire, term, 5 years, gone. So,
But also the annexers, which is annex laws regarding research guidance, paragraph 11, they have stated from reliable sources. It is not a genuine document issued by the Dibrugarh University Authority. It was a type copy by the petitioner or any other person's lordship.
Okay. Mr. Y.S. Manan, learned counsel for the petitioner. Mr. K. Gogoi, learned standing counsel for the Higher Education Department, appearing for respondent numbers 1 and 2. And Mr. P.J. Fukan,
from
learned
3, 4,
counsel
5,
appearing
and
for
6,
respondent numbers 3, 4, and 6.
3, 4, also 5,
No, 5, your Wakalalam is not there.
There was an order, earlier from this honorable court, that I will also represent respondent number 5,
Oh, is it?
the selection committee. Yes, my lord. There was an order earlier part with the honorable court.
Oh, you accept respondent 5 also. Okay. Respondents were 3 to 6. Next para. By filing the writ petition under Article 296 of the Constitution of India, the petitioner has assailed the selection and appointment. As I said, the selection process initiated pursuant to advertisement dated 1/12/2017.
When the appointment
the-
was subsequent
the-
to filing, therefore I have brought it into.
For the post of Dibru College, Dibrugarh. For the post of principal, for the post of principal, Dibru College, Dibrugarh. Next, the case of the petitioner, in brief is that pursuant to the employment advertisement appearing in newspapers on 1/12/2017, the petitioner as well as respondent number 6 had put up their candidature for appointment to the post of principal of Dibru College. It is projected that the petitioner fulfills all the requisite criteria and is eligible in all respects. Full stop. The petitioner as well as the petitioner along with 3 other persons, including respondent number 6, appeared in the interview on 12/1/2018. The selection committee selected the respondent number 6 and placed him in the first position, and the petitioner was placed in the second position. Thereafter, the matter was processed and sent for approval to the Director of Higher Education for within bracket respondent number 2 for approval and appointment. Full stop. The petitioner had submitted a resignation dated 17/1/2018 in respect of the selection process. Next, the learned counsel for the petitioner has submitted that during the pendency of this writ petition, he has come to know that the respondent number 6 had been appointed as principal of Dibru College by an order dated 30 January 2017, 18. And therefore, the said appointment order was brought on record by filing an additional affidavit. Next, the learned counsel for the petitioner has submitted that insofar as the petitioner is concerned, he was a research guide of Periyar University, as well as, what is the second university?
Vinayak Mission University.
Vinayak
Mission.
Mission University. He submitted that his guideship was approved for these 2 universities on 15/6/2007 and 16/10/2007 respectively. However, after 2009, it was settled that one cannot be a guide of a different university situated outside his concerned university. Full stop. Where is this OM of 9/7/2012?
That I have annexed in my affidavit in reply. Affidavit in reply. Lordship will find at page 8. 9 July 2012. 12.
So it is submitted that subsequently the Higher Education Department, Government of Assam, by an OM dated 9/7/2012, has directed that no off-campus center of the study center or centers throughout franchises be opened by any university outside their specific territorial jurisdiction. Hence, it is submitted that between the period 15/6/2007 till 2009, the guideship experience of the petitioner would remain, which would make him eligible for being selected and appointed to the post of principal of Dibru College. Full stop. In respect of the qualifications and experience of the respondent number 6 is concerned, it is projected that as per the list of PhD supervisor annexed to the writ petition as annexure L, the name of the petitioner does not appear as a PhD supervisor in the arts, what are the three streams? Arts,
Commerce and Science.
Commerce and Science stream of the said university. So it is submitted that in respect of specific averments made in paragraph 10 of the writ petition regarding lack of experience of petitioner as PhD supervisor and at Dibrugarh University, there is no specific reply by the respondent number 2 in their affidavit in opposition, and that the respondent number 6 has also not filed any affidavit in opposition to controvert the statement made by the petitioner. Pusta. It is submitted that in para 10 of the affidavit in opposition by respondent number 2, comma, the reference was made to the UGC regulation 2009. In respect of UGC within bracket minimum standard and procedure for award of MPhil public PhD degree bracket close regulation 2009, by which a university cannot hire the service of a faculty member of any college or teacher of another university. So it is submitted that the petitioner has no grievance against the said 2009 regulation. But first of however, comma, it is submitted that the applicability of the 2009 regulation of UGC as well as the notification issued by the government of Assam Higher Education Department dated 9/7/2012 would both have prospective application, comma, which would not disturb the qualification acquired by the petitioner as PhD supervisor for Periyar University and Vinayak. What is that name? Vinayak Mission University. Stop. It is by referring to a list of principals of colleges in Assam, comma, it is submitted that several incumbents had the experience of guideship from universities outside the jurisdiction of the state. So accordingly, it is submitted that the petitioner cannot be singled out as disqualified in respect of his guideship experience from 2 universities referred above. So in support of his submission, the learned counsel for the petitioner has cited the case of Annamala University versus so-and-so, 2009 4 SCC 590, followed in so-and-so, within the 2018 16 SCC 33, sorry, 533. I've left out anything?
Oh, one more thing, Your Lordship, the screening committee has also found me eligible. Screening committee has also found me eligible for the post of office. That also I have annexed.
Okay.
That
Moreover, the
next-
screening committee also found the petitioner otherwise eligible. Next one. The learned standing counsel for the respondent numbers 1 and 2. Has produced the records relating to selection and appointment of the petitioner. Sorry, respondent number 6 as principal Dibru College. So it is submitted that the said record was called by order dated 5/2/2018. It was called by this court by order dated 5/2/2018. requiring production of the records. Full stop. By referring to the documents contained in the record, it is submitted that the then deputy registrar within bracket academic, Dibrugarh University, by letter under reference number capital DU oblique DR dash capital A oblique 12 dash 1 oblique 12 oblique 95 dated 26/4/2012, addressed to the respondent number 6, has stated that as per decision of the meeting of Research Council in Science held on 4/4/2012, he was considered eligible for supervising PhD work in Dibrugarh University. He is also referred to notification under reference number capital DU oblique DR dash capital A oblique 11 dash 1 oblique 1135 dated 14/12/2015, issued by the deputy registrar within bracket academic, Guwahati University, which discloses the placement of one Hemamoni Das within bracket life sciences under the respondent number 6, as well as one Professor P.K. Borua, BORUA, of Department of Life Sciences from Dibrugarh University. The petitioner, namely Dr. Jitu Buragohain, from Department of Botany, Namrup College, and P.K. Borua also, as supervisor with effect from 16/3/2015. So accordingly, it is submitted that the respondent number 6 was an accredited supervisor for supervising PhD work under Dibrugarh University. And therefore, the selection and appointment of respondent number 6 was not vitiated. It is further submitted that as per the appointment order dated 30 January 2018, The term of appointment was 5 years, which has expired. So hence it is submitted that the adjudication of this repetition would only be an academic exercise. Next paragraph. The learned counsel for respondent number 6 has submitted that as per instructions received by him, the petitioner would, the respondent number 6 would superannuate on 31/3/2023. And therefore, in the meanwhile, the period of appointment of the petitioner, of the respondent number 6 has been extended up to 31/3/2023. So he submits that he would rely on the submissions made by the learned standing counsel for respondent numbers 1 and 2. I'll read this and then I'll pass the orders in chamber. It will be released tomorrow. I dictated because otherwise I wouldn't have missed something if it's not in your presence. This I'll keep for some time. We'll get it tomorrow. I'll take a break and come back.
Milord, regarding that Annamala University case, Milord. Milord, Kalyani Mathavinam case may be, Milord, important, Milord. Milord is reflected in the Orsana Sharma's case, Milord, paragraph 31. Paragraph 31, Milord. 29, 30, 31. As regards State University, the UGC regulation is not mandatory, directory. Paragraph 29, 30, 31. 31 is not relevant. The 2015 Supreme Court case, Kalyani Mathavinam. That Annamala University case has also been discussed in Kalyani Mathavinam. I think it would have some relevance in our case. As for Central University and Central University colleges, the UGC regulation is mandatory. But regarding State University and state colleges, is directory. And this proposition is now holds the field.
Yes, you said yes.
My lord,
Dibrugarh University has received grants from UGC.
my lord.
So this judgment would not apply because here the additional advocate general then made an argument that the university has not adopted it.
Yeah.
Correct.
My lord.
And then it says, in this paragraph, it says that whether the UGC regulations is mandatory for teachers or academic staff is it deemed to be universities whose maintenance expenditure is met by UGC. So therefore, that is excluded. Once UGC gives a grant,
My lord.
then you can't say that I receive your grant, but I don't follow you.
It will be refunded back, my lord, otherwise it will be refunded back, my lord. The,
Question of refund doesn't come when you have taken a grant. You don't take a grant just to refund it. The fact that you have received a grant, everyone university has received a grant, that itself is an acceptance of their regulations. So you are out of this judgment, doesn't help you.
my lord. I cannot recollect, my lord, there is one judgment, my lord, regarding that refunding aspect, my lord.
No, question of, you see, that is for the universities to say that, no, you see, why would somebody take a grant and then give it back?
It's a major punishment, my lord. So, my lord, the UGC will direct to refund the entire amount to that. My
No,
lord.
that is not the basic inquiry we are making. But the fact is that you have cited a judgment.
Yeah.
And this judgment in paragraph 31. Two, the proposition is that UGC regulations are mandatory to teachers and other academic staff in all central universities and colleges. And institution deemed to be universities whose maintenance is met by the UGC. So UGC is funding your Dibrugarh University, so it is excluded.
But in that Archana Sharma's case, my lord, if your lordship goes through that judgment.
No,
my
I
lord,
think that is why that is why I'm making a proposition to you. You see, this is on the premise when the additional advocate general made the argument. He did it on the premise that Guwahati University was not receiving UGC's grant, and therefore it has not adopted. Now the fact is that once the UGC guidelines you see, to put it differently, since you are a council of Guwahati University,
Yeah.
I can ask you and you can respond to it. You see, for the purpose of academic matters relating to the what you call the guidelines regarding maintenance of the academic standards, Do you have a regulation?
My lord, there is no separate regulation, my lord. My lord, for PhD and MPhil, my lord, some regulations are there, my lord, but basically, my lord, it is the UGC regulation, my lord.
It is
They
followed by
follow.
default. That is followed by default because nobody is, the state government has never asserted that it will have its own policy. The reason being that if the UGC guidelines are not being followed, then you don't maintain that standard.
Yeah.
And that is why insofar as UGC is concerned, there are also judgments. We say that the UGC judgments, the UGC guidelines will prevail because it maintains the academic standard.
My lord, that portion of Sharma's judgment, my lord, the additional advocate general's, my lord, stand that Guwahati University, has not adopted the UGC regulation. My lord, in spite
Now,
of, my lord,
let me put it in another way. Now, let us say that the Guwahati University today comes up with a regulation and amends its what you call the statute.
my lord,
The state also makes amendment to the University Act.
Yeah.
And says that now, well, even class 5 pupil of class 5 are eligible for PhD. You don't need metric, you don't need graduation, you don't need any sort of degree. Class 5, you are eligible for PhD.
my lord.
Now, what happens then?
Lord, aspect of wisdom, my lord, I don't think that
No, let us see.
only the
No,
UGC peoples are wise and
no, I'm not
Guwahati
saying that.
University
I'm
people
not
or
saying that. But suppose,
government people.
supposing this, what I'm thinking of is never going to happen. But let us say for the time being,
my lord.
it is accepted. Then what happens? There's the UGC said that you have to be a postgraduate to become eligible for being a
Yes.
scholar in PhD. University earlier also has the same thing, but today it is amended.
Class 5.
Class 5.
It will be a legal.
No, I'm not saying that. You see, that is permissible. You will find boys who are undergraduate being conferred PhD degrees. They're not one. I can give you examples of at least 10. 10 students who are undergraduates got their PhD degrees.
Exceptional, my lord, caliber,
Exceptions are there because
like
even for
Stephen
metric,
Hawkins, my lord.
even for metric examination, if the age limit
Yeah.
prior to that, if a boy or girl expresses his acumen, even the university will the board will permit. There is a special resolution taken
Yeah.
to permit him to become a to do it before the time.
Yeah.
Even our board of secondary education, Assam has done it.
These are exceptional cases.
These are exceptions.
And they have got that discussion, my lord.
The discussion, academic discussions are there, but not as a normal course.
But this personal summers is little bit also contradictory for me also, little bit disturbing. On one hand, Guwahati University receives UGC grant. The other hand, my lord, UGC regulation is not mandatory for Guwahati University as well as Dibrugarh and other state university.
No,
That proposition of law, my lord, little disturbing for me. Anyway, my lord, I
no, but it's we are not discussing the judgment, but we are trying to just understand.
since Annamala University case has been cited by my learned friend Miller, so that Annamala University case has been discussed in Kalyani Mathavina.
Because here, this judgment was passed on a different reason altogether. Here, what had happened,
Selection of
the
vice chancellor.
selection of vice chancellor, and since he was the previous vice chancellor, he was otherwise a member of the executive council. And therefore, it says that the Assam government came with a proposal that he would, there will be another person who is not connected with the university. And therefore, the rules were tweaked.
Sharma is not relevant. Archana
it-
Sharma as well as Kalyani Madhivanan also not relevant here. My lord has already decided Lordship, whether he has the PhD research guide or not, Lordship. If this. no relevancy is-
UGC guidelines will prevail. Because in one of my orders also I have held that. It will be the UGC guidelines which will prevail. And that is the reason for not accepting the PhD degrees from Periyar University. Because there I have held that the UGC guidelines will prevail and that prohibited the granting of degree outside the territorial jurisdiction. That was the argument of Mr. Gogoi.
Even Lordship, even otherwise also Lordship. Regarding Lordship, the qualification prescribed by the UGC Lordship. UGC regulations was made Lordship under section 23 of the UGC Act Lordship. Section 23 UGC Act is binding all the universities, even Lordship, the conventional law Lordship, any universities Lordship.
No, that is what I had to go
Lordship,
you, but
and-
now he is placing this judgment.
Lordship,
Archana
The
Sharma.
Archana Sharma and Kalyani Madhivanan in this particular case Lordship.
No,
In my view, Lordship, that is not relevant. My lordship to decide, Lordship, whether he has the UGC required qualification or not. Record reflects that, Lordship, he has the UGC required qualification, Lordship. My lord have to decide, Lordship, whether that particular record is, Lordship, as per UGC's relevant UGC's qualification or not. Legal point,
No, because this would lead, this would
Annamalai
lead to a difficulty.
Annamalai says that, Lordship, paragraph 32 the Annamalai case says that, Lordship, the regulations which was made under section 23 of the UGC Act, Lordship, it is binding to all conventional as well as open universities also, Lordship. Because section 23 says that regarding standards of education, Lordship, and the qualification prescribed. On the basis of that, Lordship, the UGC regulations are made to maintain the higher standard, Lordship.
No, that's why I have
Lordship.
accepted that
Lordship.
argument. That argument of Mr. Gogoi was accepted by me.
Lordship.
So therefore, if I now take cognizance of this, there will be difficulty.
No, we leave it to your lordship, my lord.
Because Lordship says already one moot question Lordship has to decide. That is the only issue, Lordship. That part, other part is not relevant, Lordship. Here.
Because you see, this issue, we will not decide for a different reason. The reason being that in order to adjudicate this point, all the universities in Assam have to be before the court,
Lordship.
because otherwise it will affect their interest. I can't give a verdict which will affect them without hearing them.
That autonomy aspects would also come into some.
No, it will vitally affect them.
Lordship.
It will affect even the Guwahati University in whose favor this judgment is given. Because then I'll have to distinguish and then refer it to a larger bench,
Lordship.
have the matter heard,
Lordship.
which will affect all the universities. I'm not going to do that.
Lordship. Apology.
When it is only 1 month more left for this.
Apology, Lordship.
Most of life. I'll inform the other side, my lord, regarding.
No, not required.
My lord, here in this case, my lord, we have filed an affidavit. My lord, here, Lordship comes to the affidavit, Lordship. petitioners were, my lordship, non-formal education supervisors. They were under that scheme, your lordship. So the scheme is no longer there, and this thing, the prayer was for reabsorption. Accordingly, we gave them a hearing and all that, my lord. And then, my lord, according to the court's order, we gave them a hearing, and then, my lord, in compliance, we gave them a hearing, and on this thing, we rejected their claim, your lordship. They rejected their claim on the basis that they are not qualified, your lordship. Petitioners basically, your lordship, do not possess the required qualifications to be appointed as assistant teachers in the LP schools. As per the, my lord, this thing, they have to be TET qualified. In this case, my lord, they are not TET qualified. They have to be, according to the, my lord, notification dated 23 August 2010, that has to be complied, my lord, NCT. So all those, my lord, guidelines have not been followed, my lord. Where they are not TET qualified, they don't have the requisite qualification also.
Where is the disposal?
My lord.
Where is the order of disposal of that representation? Where is that speaking order?
My lord. The affidavit we are not filed, we will,
No, it can't be dismissed. You are education department, you know what to produce, what not to produce.
you know, this thing, order is at this thing, my lord, page 101 of the petition. 101 of the petition.
101.
It's annexed in the main petition. Page 101, annexure 16.
Yes, Mr. Sharma.
Yes, Your Lordship. Your Lordship, the impugned order, Your Lordship, is at page 101.
Yes.
The prayer in the earlier round of litigation before this honorable court, Your Lordship, was for absorption of the petitioners pursuant to the steps which were taken by the state government from time to time. The earlier petition, Your Lordship, was disposed of by the impugned order, which is at page 101 before Your Lordship.
Yes.
The reasoning which has been given by the state is that the Assam Right of Children to Free and Compulsory Education Act 2009 came into force with effect from 27th of August 2009. And the state government of Assam also enacted the Assam Right of Children to Free and Compulsory Education rules with effect from 3/11/2011. In addition, the National Council for Teacher Education, Government of India has issued a number of notification guidelines from time to time regarding the minimum qualification for a person to be eligible for appointment as teacher as elementary level, lower primary and upper primary schools. Besides educational qualifications, other professional qualifications as prescribed by NCT, Government of India, passing of TET is mandatory for appointment of teachers subsequent to the enactment of the RTE Act. As per the Honorable Guwahati High Court order dated so and so, the matter was discussed with the Finance Department on 14th of June 2019 and has been concluded by minutes dated 14th June 2019 that in view of the prevailing guidelines of both central and state government, absorption of the petitioners as elementary school teachers in terms of the judgment of an order dated 25/7/2007 passed in WPC number 2694/2001 is no longer possible. In terms of the order which is dated 25/7/2007, Your Lordship.
You see, Mr. Sharma,
Yes, Your Lordship.
the case you are developing.
Yes.
Is that the requirement of your considering your absorption
Yes, sir.
would be on the basis of your eligibility as on 2006,
Yes, yes.
correct?
Yes.
That is in short
Yes, yes,
your
yes,
your
that
stand.
is short my submission.
But you see, if today the eligibility is considered,
Yes,
assuming we consider it even for 2006.
Yes.
But the appointments would be always prospective, made today,
yes,
and as on today, the RTE Act
yes. It holds the field. It holds the field.
is hold the field.
It holds-
Now there are judgments of this court as well as the
Yes.
Supreme Court, which affirms
Yes,
the TET requirement,
yes,
and more so because in one of the cases regarding the applicability of TET,
Yes.
I had authored the judgment.
Yes.
So therefore, I have already held that the requirement of TET is a mandatory requirement.
Yes, it is mandatory. In fact, your lordship, I cannot dispute with that fact, and also the fact that we do not have the qualifications as required. And these are on record, and I cannot dispute those facts anymore, your lordship. What has happened, transpired on the earlier occasion before this honorable court, is that there was a discussion, deliberation on the government's part to absolve us on non-teaching post. And 75 petitioners before this court, your lordship, some of them have retired. In fact, there has been no communication to that end forthcoming. In fact, it's not warranted from the state government, but the prayer in terms of equity, what we submitted before this court was that teaching posts cannot be conferred to the petitioners, which is a fact. I cannot dispute that. Now, the fact that they've waited for so long and the process had culminated at an early point in time, thereafter they were promised, but still, nothing concrete had happened. And in the meantime, the regulations had come into force. On the last occasion, this honorable court in that regard had directed the BTC to file the reply. There's an affidavit filed by the state government also, which states the requirement that is needed. Now, the BTC will also be filing the affidavit in the same regard. My prayer before this court is to direct the state to just consider whether we can be absolved in non-teaching posts. We have made an amendment to that effect also.
No, you see, that is very difficult,
Yes, understand.
Mr. Sharma,
Yes,
because normally I would not direct a disposal of a representation or to
Yes.
consider
yes,
unless I spell out
yes,
some right which is accrued in your favor,
yes.
some legal right which is accrued in your favor. Now, you see, there's one part which you are right, that there is a human element, to consider it sympathetically. But the fact remains that the hard reality is that in a school,
Yes,
the strength of the teaching and non-teaching staff have already been defined.
yes,
That is under the reorganization Education Act. Now, with that defined and constricted sphere which we have to move around, you'll have to show us a way that how this can be implemented. There are two aspects to it. Number one, if there is a vacancy which is prescribed, then it is the normal employment standard is that it has to be advertised and it has to be filled up, and you can have some relaxation for the experience you have or the service you have rendered in the past. The other is to completely overlook the public employment aspect, and then make an arrangement to have selection made only through the through the selected few. But the second option is again
it bypasses the entire public.
uh,
It does. There are difficulties in this matter. Your
there are
Lordship.
difficulties there.
There are difficulties.
Because you see, main thing is the state government. If the state government doesn't permit, the BDC will not be able to.
Then we don't have a case. Then I cannot argue my matter before this court, because the lordship has rightly agreed that a lot of water is thrown under the bridge. Particularly in the court.
No, not that. We are truthful to in what we are doing, but at times,
Understand the lordship's limitations also.
you must also have that reality in the frame where we are working. Yes, Mr. Nayak.
Lordship has must have seen that order, speaking order.
I've seen that now. Mr. Sharma is taking a different. He is addressing us differently. He's trying to build up an argument that, well, what has happened and the limitations which are there. That is one part. But can there be a discussion in the BDC to have them absorbed in a non-teaching post?
No, Lordship. Basically, your Lordship will see irrespective of all these litigations, Lordship will see one thing. They were engaged against a scheme, Lordship, post created under a scheme. And the law is settled, Lordship, scheme and the post created under that scheme are coterminous. So once the scheme got abolished, Lordship, their post automatically got abolished. That is the position, Lordship, legal position. And that has been settled by the Supreme Court, Lordship, in one of my cases. That has been settled by the Supreme Court. These are all executive exercises there, Lordship, subsequently. If all these things are overcome also, Lordship will not be able to overcome that Supreme Court judgment, Lordship. That is the situation. Citation to one line. Abdul Kader versus Director General of Police, Assam.
This is Guwahati case or Supreme Court
Yes,
matter?
it is decided by the Supreme Court, Lordship.
Paragraph 8. My lord, in the Indian,
How do we spell Abdul Qadir?
my lord, Muhammad MD,
So just a moment. Yes.
KADIR and another
KDIR.
KADIR versus Director General of Police, Assam. It's reported on 22nd April 2009.
2009, yes.
Lord, in the India Canon, my lord, this thing, it's paragraph 8 in the India Canon citation.
Para 8.
Of the India Canon citation.
Yes. How does it start?
We may next consider.
We may next consider. Okay.
My lord, the middle, if your lordship comes, it's there. From the artificial annual breaks, it starts from there. Current. Lord, may I read?
Now their service has been terminated.
Yes, Lordship. Subsequently, once the scheme got abolished, Lordship, their services were also.
With effect from when?
Their initial appointment was in the year 2001, Lordship.
And terminated on?
Come on.
31/3/2001. Page 101 says
Page 43 lordship.
Page 101 says 31/1/2001.
Yes, Lord. Page 43.
31 February 2001. 31
15.
31.
3.
3/2001. And where is the order in this WPC 2964?
Yes, at page 67, Your Lordship,
269.
page 67. The order starts at page 68, 67 of the recitals, Your Lordship. And this is based on an affidavit that was furnished by the state government, Your Lordship. The last paragraph of page 68. Ms. So-and-so, learned SC, Education Department, has submitted that a detailed affidavit in opposition has been filed in WPC number 2319 of 2005, which covers the instant writ petitioner, also wherein at paragraph 6, it has been stated as follows. That a deponent further begs to state that with a view to adjusting supervisors of non-formal education against the post of LP and UP school teachers, the government had allowed to appear before the Special Selection Committee. This was done in the month of February and March 2006, after announcing in the newspapers. It may be mentioned that out of the 560 persons who appeared, 197 were found to be eligible, including reserve categories. The required educational qualification was HS passed with at least second division. The recommendation of the selection committee has since been sent to the government by the Director of Elementary Education. The statements made in paragraph 6 shows that the recommendation of the selection committee has been sent to the government by the Director of Elementary Education, meaning thereby that the matter is now pending before the government for taking necessary action. In view of the statements made in paragraph 6 of the counter, as mentioned above, the government is directed to take decision in the matter, and the same shall be done within a period of 3 months from date of receipt of a certified copy of this order before the appropriate authority. Upon hearing the learned counsel for the parties and on consideration of the materials available on record, the writ petition is disposed of with the above direction. Your Lordship would then kindly come to page 80. Just for a moment, Your Lordship. Page 80 and page 81. Page 81, Your Lordship. This is a communication dated 4th of January 2011, addressed to the Commissioning Secretary, Your Lordship. I am directed to enclose herewith a list of 281 drop teachers recommended for appointment by the High Power Committee constituted by the government as per directions in the order dated 1/9/2003 of the Honorable High Court in WPC 1571-1998, and another list of 195 retrenched supervisors of erstwhile non-formal education as per directions in the order dated 25/7/2007 of the Honorable High Court, passed in WPC 2694/2001, and request you to kindly move the Honorable High Court for grant of leave to issue appointment to the persons in the above mentioned list. Page 81, Your Lordship, are the number of posts being highlighted in different districts in the state of Assam. This exercise had taken place after the RTE Act had come into play, Your Lordship. This is dated 2011. The RTE Act came into play in 2009 and the rules came in 2011. This was in spite of the requirement as mandated by the RTE Act. There were posts which are highlighted, the posts which are earmarked. Supervisors had gone through the selection process constituted by the government, and now they have come with a plea that the RTE Act restricts my entry into reabsorption. And with utmost regard to my learned senior, your lordship, the matter in Abdul Qadir may not be applicable on facts in the matter. The case cited by my senior, Muhammad Abdul Qadir versus DGP Assam. The facts which have been cited, although similar, will not apply in this case, your lordship. The challenge there was made to the stopgap termination start the PIF additional scheme. Here, the scheme had ended. Thereafter, we had approached this honorable court, the honorable court interfered. The government also reciprocated. And now.
No, he's referring to only one part of it. That once there is a scheme, appointment under a scheme, it is co-terminus with the scheme.
We have not challenged that scheme. That scheme is long gone and we understand that.
That is the only point he is referring to,
The
Mr.
government
Nayak.
reciprocated till the last moment and now they have left us high and dry. And this is also. a
No,
fact.
but you see, from this orders which are there on record, what I understand is that number one, till the government takes a decision, there was a stay for all the engagements.
Yes, Babu.
So after that, there is a writ appeal. In the writ appeal also, there was the stay operating. And then the government approached this court, and therefore this court relaxed the what you call appointments for a particular group of persons. Now against that, the state went to Supreme Court, and Supreme Court says that well, the entire ban goes. So once the entire ban goes, then the protection which we are earlier notionally having of stay of the all this, that also goes in with that. So therefore, when free appointments are made, unrestricted appointments have been allowed, then to come back and say that 2006 recruitment, what you call your qualification as on 2006 be considered.
Now
I think
I'm not arguing on that, your lordship, because I understand, again, I cannot dispute on that fact as well. And these are matters pertaining to primary education and we cannot dispute the fact. It is only my submission that bona fide expectations are arising, your lordship, by the action of the government. And there's an unfortunate-
I can only say that in the recruitment process, which will be initiated, you will have a case-to-case basis. You can apply for relaxation of your age and all. And that will be considered by the competent authority in accordance with law.
But educational qualification,
No, not on the teaching post.
not teaching-
Mr. Sharma says that non-teaching post also they are ready to
Yes.
work.
is the money reserved?
No, age relaxation, you will always consider case-to-case basis.
To the permissible level also.
Yes, definitely. Therefore, that is what is permissible. Most of them will not be will be out. Mr. Sharma says that
Yes.
you'll be in the verge of retirement, but it can still be considered.
Whatever little they can get.
But only relaxation as regard the age only, Lord.
Age only.
So far as other criteria are
no,
concerned,
no,
no,
no.
they will be considered just as an ordinary
Huh.
candidate. Lord.
For non-teaching.
Mr. M. Sharma, and counsel for the petitioners. Also heard Mr. G. Pokalyal, and the government advocate appearing for respondent number 1. Mr. A. Fukal, standing counsel for respondent numbers 2, 4, and 5.
Dr. I'm appearing for 6, 3 and 6, Lord.
Okay. And Mr. P. Nayak, learned standing counsel for respondent numbers 3 and 6. In this writ petition, it is claimed that the petitioners were instructed were appointed as instructors in the year 1983-84 under non-formal education projects. Full stop. In course of time, the petitioners were appointed as supervisors under the said scheme in the year 1992-93. Full stop. However,
They were released on 15
No. however, as this said scheme came to an end on 31/3/2001, the services of the petitioners were terminated with effect on 31/3/2001. Correct.
15/3/2021 were the release orders which were issued. The discontinuation was in effect from 1/4/2001. From the month of April, so they were
In
discontinued.
that regard,
Yes,
formal orders of termination were issued on 15/3/2021.
yes, Your Lordship.
Sorry, 2001. Good start. The petitioners and several others similarly situated persons approach this court from time to time for considering their reabsorption in service. Full stop. It is not in dispute that several orders were passed by this court in different writ petitions, directing the state government authorities to consider the claim of the petitioners in accordance with the then prevailing policies. Full stop. It is projected that in connection with WPC 2319 of 2001, the Director Elementary Education Assam, by filing an affidavit in opposition, has stated that the retrenched supervisors were asked to appear before a special screening committee constituted by the government, and accordingly, names of 195 supervisors were selected for reabsorption. During the set process, this court, in a suo motu proceedings registered as WPC 1457 of 2010,
It's
considered the issue relating to appointment and by order dated 5/3/2010, restrained, passed in the said petition, restrained the state respondents in carrying out fresh recruitment in LP/UP schools in the state of Assam. So it is projected that the proceedings was taken up in a writ appeal. And thereafter, the matter was taken up to the Supreme Court of India. And the said court, by order dated 8/2/2012, passed in SLP within bracket C number 4340 of 2012, lifted the ban in the recruitment process. Full stop. It is posited that even thereafter the appointments are not made. And thereafter, another writ petition being WPC 243 of 2015 came to be filed before this court. And by order dated 21/5/2018, this court directed the respondent authorities to convene a meeting and decide the prayer made by the petition, by the retrenched, by the petitioners.
Yes. As elementary school teachers. As elementary school teachers.
As elementary petitions prayer for appointment as appointment in for the appointment as elementary school teachers. Full stop. The Commissioner Secretary to the Government of Assam, Elementary Education Department, by a speaking order dated 19/7/2019, which is impugned in this writ petition, had mentioned therein that the matter was discussed with the Finance Department. Relating to appointment of 195 retrenched supervisors. And as in the meantime, the Assam Right of Children to Free and Compulsory Education Act 2009 came into force from 27/8/2009. And rules thereunder was framed on 3/11/2011. And moreover, as the minimum qualifications for a person to be eligible for appointment as teachers at elementary level within bracket LP/UP schools bracket closed was framed by the NCTE, amongst others, prescribing the professional qualifications as well as requirement of passing TET examination. It was held that the absorption of petitioners as elementary school teachers in terms of judgment and order dated 25/7/2007, passed in WPC 2694 of 2001, was no longer possible. So accordingly, the claim of the petitioners was rejected. So accordingly, by filing this petition in Article 226 of the Constitution of India, the petitioners have prayed for a direction upon the respondent authorities to appoint the petitioners in terms of the said judgment and order dated 25/7/2007, passed by this court in WBC 2694 of 2001. And to quash the impugned communication dated 19/7/2019, issued by the respondent number 2. Next paragraph. The learned counsel for the petitioner has referred to the materials available on record. And it is submitted that the petitioners had rendered their service for more than 16, 17, for more than 17, 18 years, for about 17, 18 years from the year 1983-84 till 31/3/2001. And therefore, the respondent authorities should be directed to absorb the petitioners in any teaching or non-teaching posts. First of all, it is further submitted that the respondent authorities were required to consider the claim of the petitioners for absorption in terms of their qualifications which existed in the and the norms for appointment which prevailed in the year 2006. Mr. Sharma, why we have used this word 2006 has come from where?
2006, your lordship, if your lordship can kindly come to page 57.
Yes.
This affidavit, your lordship, is dated 9th day of January 2007.
Okay.
This
2000,
was when the exercise was stated to be
Okay.
completed, your lordship.
2006.
Yes.
Stop. The learned counsel for the petitioners has submitted that the cutoff year of 2006 was taken from the fact that the competent authority had passed a speaking order in this regard on 8 November 2006, right? That is at page 16. Last 4 lines.
Yes, your lordship. Yes, your lordship.
And in that regard,
Yes.
affidavit in opposition was filed by the
Joint Secretary.
director of by the Joint Secretary Education within
Yes.
bracket elementary
Yes.
on 9/1/2007.
7.
So it is submitted that even if the court is inclined to take a view that the requirement of the petitioners to hold prescribed qualification, including TET, was required to appoint them as, to reabsorb them as the petitioners as teachers in the elementary education department. Their cases it would be appropriate to direct the respondent authorities to consider the absorption of the petitioners in any non-teaching posts. Okay, we'll continue at 2. What was the last paragraph?
It is the appropriate to use the responding authorities to consider the absorption of the petitioners in the municipal context.
Okay. For contra comma, the learned counsel for the respondent numbers P and 6.
Six is for the BTAD.
Yes,
Education and finance are the.
no, finance and BTC, he's for both. Has submitted that as the scheme of erstwhile non-formal education had terminated on 31/3/2001, the appointments made to the petitioners were co-terminus with the end of the scheme. And accordingly, it was not possible to absorb the petitioners in any teaching posts in the elementary schools. In view of the changed circumstances and application of NCT norms, which required that our teaching staff should be TET qualified. So accordingly, to submit it that it was not possible to implement any scheme for absorption of the petitioners or to consider the claim of the petitioners in terms of order dated 25/7/2007 passed by this court in WBC 2694 of 2001. Full stop. A similar stand is taken by the Learned Counsel appearing for the Lawrence Stanikos for the Elementary Education Department. Was referred to the affidavit in opposition filed by respondent number 2. Next one. On the consideration of the matters in entirety. The court finds that that it is an undisputed fact that the petitioners who form a part of retrenched supervisors under the erstwhile non-formal education are persons whose name appear in the list of 195 retrenched supervisors who were sought to be reabsorbed by the authorities. In view of recommendation made by the High Power Committee constituted by the government as per order dated 1/9/2003 passed by this court in WPC 1571 of 1998 and order dated 25/7/2007 passed in WPC 2694 of 2001. Full stop. At the relevant time, the respondent authorities who are sympathetical to the issue raised by the petitioners, and not only a list of 195 retrenched supervisors were finalized for the purpose of reabsorption. However, this court was also moved so as to enable the respondent authorities to appoint the petitioners and others similarly situated persons. It is also not in dispute that the petitioners were appointed under non-formal education scheme, which has come to an end on 31/3/2001. And that the service of the petitioners were retrenched with effect from 31/3/2001 by virtue of orders which were passed on 15/3/2001.
Yes.
Full stop. Next paragraph. For the purpose of engaging teaching staff for the LP of the UP schools, which are under the Elementary Education Department, the current requirement as prescribed by the NCTE is that the teaching staff should have the basic educational qualification as well as professional qualifications prescribed for certain subjects. But above all, there is a requirement of a candidate to have passed TET, which was made mandatory for appointment of teachers subsequent to the enactment of right to free education and what is the full name? Right to free education and
Education. The Assam Right of Children to Free
compulsory education.
and Compulsory Education
Education
Act,
2009.
2009.
Most of the norms laid down by the NCT cannot be relaxed. So therefore, notwithstanding that at one point of time, the respondent authorities were making effort to appoint to absorb the petitioners in teaching posts, but with the prescription which has been given by the NCT, the court does not find that any illegality was committed by the Elementary Education Department in passing the speaking order dated 19/7/2019. Full stop. Next slide. This stage, the learned counsel for the petitioner submits that the cases of the petitions can still be considered for their absorption in the non-teaching posts in view of the fact that the petitioners have rendered about 17 years of service in the Elementary Education Department, and they have been moving the scope for their rights since the year 2001 and have spent almost 22 years in litigating for their rights. Full stop. Considering the above submissions, the court is inclined to provide that it could be open to that the respondents in the Elementary Education Department shall entertain the applications of the petitioner for appointment to any non-teaching posts under their establishments. And that the competent respondent authorities shall consider the prayer of the petitioners for considering an exemption of their age bar. Or if such an application is made individually by the petitioners. And if such an applications are filed, or the competent authority of the respondents shall consider the same in accordance with law. First one. This observation shall not be construed as if the essential qualifications have been relaxed in any manner. First one. The petition stands disposed of with the observations as indicated over.
I'm grateful about. One clarification, Your Lordship. The petitioners here hail from different districts in Assam, falling under BTAD as well as the non-BTAD districts. So if Your Lordship deems it fit, Your Lordship, there can be two sets of application that goes Director of Elementary Education. Director
No,
of
no,
BTC,
that
or
that will be
individual.
individual.
Individual. I'm great. I want to. clarify. Yes.
I already clarified in the order. It will be individual because in an earlier round,
Yes,
I disapproved of the common application
yes.
made by several persons because then the director it was director education, they will not be able to apply his mind.
Biggest task, yes, absolutely.
This Mr. Nayak. Put on the speaker. Put on the speaker.
But it will not be a special drive, Lordship. Whenever there is vacancies are notified, Lordship, they will participate, Lordship.
Just make it clear somewhere. As and when vacancy arises, the petitioner shall have the liberty to participate in the same. And just recast that language. It is only when the vacancy arises, they will apply.
Obliged, Lordship.
But Mr. Nayak, this is a human problem.
Yes, Lordship. And that is why-
People who have spent so much time of their life waiting for some type of job. I think.
Lordship, whatever
Well,
you consider, Lordship. I'll call it.
mm,
Obliged, Lordship.
Yes, in your matter, I had adjourned it. You need not be here. I told you I had adjourned it.
Your Lordship, State Bank. My
Next
lord, this is a matter
This is the-
wherein your Lordship, this honorable could directed them to give instruction as regard non-payment of salary to the petitioners. Lordship, order is at page 40 to 19. I am told that order has been passed, my lord. Let them put it on record by way of affidavit, my lord.
Both sides are duly represented. Mr. R. Mazumdar, standing also for the Elementary Education Department, submits that that he is instructed that the order of this court in WPC 2710/2017 has been complied with.
My lord, they have been offered appointment as teachers pursuant to the screening committee, my lord. Subject to the condition that they will give up all their past claims.
By passing in conditional order, he pays for and is granted time to bring it on record. This after
10 days.
After the BU vacations. 10 days.
immediately after the ensuing BU vacations.
Fine.
By 10 days,
Yeah.
he'll file his affidavit.
We'll do so because I'm just trying to adjourn it after BU because of the immense pressure we are having for that
Yes,
programs. So please make a mention if it is not listed.
Lordship obliged.
So then.
You have the records with you? Mr. Mazumdar, you have the record with you?
I'm not with the records today, madam. They have to, plus you will give me some time, I'll just find out. Because in the morning, they had sent me some instruction. I had written back to them saying that no, we are supposed to produce the
Records.
reports. Just find out.
Only one humble prayer. The first order is dated 9/11/2020. Your Lordship, it's according to the mission director from Sarva Shiksha Abhijan Mission, respondent number 3 shall produce scanned copy of the relevant records. And thereafter, twice this
And there's-
order has been reminded
to the respondents.
It's okay, Mr. Mazumdar is conscious. That's why he said that he has written it back. Just wait for some time. Entitlement of salary. Question of entitlement of
What I
salary.
understood was, I think Mr. D. Dulu Mohanty is also, Mr. D. Mohanty is also appearing. He was telling me about this case that there is some confusion regarding which is the original school. So the salary has to go to the school which is provincialized. My instructions are also to somewhat to that effect only. But since we were required to produce records regarding payment of salary, that is what I had suffered. Lordship has this affidavit in opposition filed by the respondent number 10.
Because this school, in one of the schools, the name Balika was inserted.
Yes,
Correct.
First omitted. First omitted.
First omitted, then inserted.
As a result, all the anomalies started.
Okay.
It was meant to be Balika LP school.
Okay.
And the original headmaster and the assistant teachers are the present petitioners.
Okay.
I'll just try to.
For hearing 811.
May I please, Lordship?
Yes.
Lordship, this matter pertains to provincialization for the post of principal at Borkatri College. Lordship, counsel for the petitioner, Mr. A.R. Bhuya, is severely ill. Severely ill, Lordship.
Is ill.
Yes, Lordship. Lordship may take up the matter on next day.
Okay. 2014 matters, I find it very difficult. You made a mention in the morning. 2014, if I'm adjourning, I really feel bad.
Lordship, you may take up matter next week, Lordship. Actually,
No, now it goes after BU. Mister, your name?
N. A. Mazhar Bhuya, N. A. Mazhar Bhuya.
And A. Mazhar Bhuya, Government Counsel for the petitioner, submits that Mr. A.R. Bhuya, Government Counsel, holding the brief for the petitioner is ill. So, accordingly, reluctantly, the matter stands adjourned today. All the respondents are represented. List the matter after ensuing BU vacations. First of it is made clear that on the next date, it is made clear that this petition is of the year 2014, on the next date, prepare for adjournment shall not be entertained.
Well,
I have pledged.
Yes.
Petitioner before Lordship.
Just now. Unless I open the file, I won't know what I'm handling. Okay, you are not awarded 7 points because of the CSD.
Lordship.
Ah.
Otherwise, Lordship, division bench judgment is in my favor, Lordship. Now, after the passing of that order, Lordship, by the division bench, now a office memorandum comes up, which says that person having PhD degree, Lordship, if Lordship, he applies in lieu of net slate, then I will not be eligible, Lordship. That is contrary to the judgment of this honorable court endorsed by the division bench as well, Lordship.
This, are you referring to page 13 OM,
Yes,
page 30 OM?
yes.
Your, please give me the relevant dates,
Yes.
the selection, what is the date of
Yes.
selection and all those?
The date of advertisement is 3/11/2016. Para 4,
Advertisement,
yes.
yes,
Petitioner applied on 12/11/16.
yes,
Interview was held on 25/2/17.
yes,
Then petitioner made an RTA application on 4/3/17.
yes,
Then office memorandum dated 25/6/2012.
yes. This only requires that persons who are PhD
Yes,
are not required to undergo net select.
yes. That is, Lordship, he is an MPhil, Lordship. After completion of his MA, he completed his MPhil and thereafter completed PhD in the year 2012. Lordship.
Okay,
Pursuant to advertisement, he appeared in that interview and Lordship, Lordship, fared quite well in the interview. And to his surprise, when the interview results were declared, he found that pursuant to an RTA application, he found that 7 marks Lordship were allotted. If Lordship comes to the office memorandum at page 30, may I read, Lordship?
yes,
Selection procedure for the post of assistant professors. Qualification for direct recruitment of assistant professors of UGC Regulation 30th June 2010.
Just a moment, Mr. Ganguly.
Lordship.
You have got PhD from where?
I have completed my MPhil from Central Institute of English and Foreign Language, Hyderabad, 2000.
Just a moment.
Yes.
MPhil,
Yes.
Central Institute,
Central Institute of English and Foreign Language, Hyderabad.
yes.
PhD
This was done when?
in the year 2007.
Yes,
And PhD degree under regular mode from English and Foreign Languages, University of Hyderabad in the year 2012. Para 3 of my repetition.
from
From
same Central
English and
Institute.
Foreign Language, University of Hyderabad.
Yes,
Presently, he is working as an assistant professor in some other college. Rather, he is working at Horukhetri College at Borpeta district. Lordship.
in Horukhetri College.
Yes.
Yes. So if I understood this correctly, You are agreed by the non-granting of 7 marks.
Yes,
Correct.
yes, that is my case.
But why under this, what is your response? Why, because of this notification of 2012? What is there which prevents your 7 marks? What is the interpretation being given?
That page 31 is the relevant part, Lordship.
Yes.
Page 32 is the relevant part. PhD research program 25 marks, PhD from UGC recognized and Government of Assam approved university. If the candidate has PhD degree in addition to eligibility requirement of NET/SLET, there will be no marks for the PhD degree if it is counted in lieu of NET/SLET, Lordship.
But then this otherwise can't be given because of this.
As it is, Lordship, this position has been cleared by the division bench of this honorable court. Lordship, for a moment, if Lordship comes to the judgment.
Where is that?
2005 for GLT 645 and
Five for GLT.
645. That is by the single bench, and thereafter, Lordship, 2011 1 GLT 431.
Six four five.
Lordship may come to the division bench judgment. 2011 1 GLT 431. Page 9 onwards.
2011.
2011 1 GLT 431. Lordship got it.
Yes.
Here it goes. From paragraph 9, I'm reading from paragraph 9. When a person's candidature is found eligible because of exemption granted, which have been declared as reasonable by the Supreme Court, it would be inappropriate in our view to hold that PhD degree holders shouldn't be given any credit for such qualification, since evaluation is to be made on the academic achievements, performance of the candidates. The selection process, in our considered view, lays down a transparent and objective norms of selection, and it would not be correct to deny 10 marks for a PhD degree holder merely because the said degree also enables a candidature to be considered eligible even without NET/SLET degree for appointment as a lecturer. Anybody who makes a legitimate entry in the fray by virtue of a PhD degree ought not to be denied the credit of marks for his high academic achievement, because if such contention is accepted, the value of the PhD degree would be greatly undermined. We further find that NET has been prescribed as a general qualification criteria, and all candidates are expected to meet the NET/SLET eligibility qualification. Therefore, not providing any special credit by way of marks for NET cannot be considered to be unreasonable merely because of special exemption from net slate qualification is granted for PhD degree holders. It is clear that a policy decision was taken by the UGC, which is a specialized statutory body whereby PhD degree holders have been exempted from the requirement of net, and this policy decision has received the approval of the apex court in Sadhna Chaudhary Supra. Therefore, this court sees no reason to interfere with the impugned decision to grant exemption from net qualification for the PhD degree holder. For selecting lecturers, the academic achievements are of paramount consideration, and considering the onerous process of obtaining a PhD degree, there is no justification for not awarding credit against a PhD recognized universally as a scholarly achievements of highest order. A PhD qualified candidate is expected to have in-depth knowledge of his subject and also the creativity and capacity to undertake higher research in the subject. We are also of the opinion that a PhD degree cannot be equated with net, and similar marks cannot be claimed for net, which has no other utility but to make a person eligible to apply for a post of lecturer. The guidelines issued by the Assam government on 23/2003 prescribing the criterion for evaluation of candidates on a scale of 100 marks is an objective process where 65 marks are earmarked for academics and PhD degree. Being an academic achievement of the highest order, the same cannot be equated with a net qualification, which is only an eligibility test conducted by the UGC or SLATE Commission. For the foregoing reason, we see no merit in this appeal and hold that the learned single judge committed no error in dismissing the repetition of the appellant. Accordingly, the appeal stands dismissed without any order on course.
Do you have the earlier guidelines of 2003? Is it available with you?
No.
You have a copy of that UGC regulation 2010? Do you have? Your post was professor.
Professor. Assistant professor.
Assistant professor. You see, I think subject to what Mr. Mukhtar and Mr. Sharma says, what I have understood is that for the purpose of assistant professor, under the 2010 guidelines of UGC, TET is a mandatory requirement. So it's not an optional requirement, and therefore, if you are taking the help of the PhD to meet that criteria, then definitely you can't be given 2 marks separately for both the categories. That is what I understand, subject to what Mr. Samoa says.
You can have the option of. If he does not have the NET qualification and entry has got by way of the PhD degree only, then the separate marks for PhD.
He doesn't get.
Yeah, but the API score table that is provided in the UGC regulation, there is 50% mark can be provided for academic records and research performance. In that column, if the selection committee provides marks against the PhD degree, then my instruction is that the collective wisdom of the selection committee UGC does not want to question. If under that particular column, because 50% marks is allotted for academic records, good academic records and research performance, API score table. So at this point, my lord, may I pray, my lord, with sincere, which folded hand, my lord, that I just this particular point is little bit contradictory. Because in one place, if we say that only because that you don't have the NET or SLATE, you are coming into the domain of zone of consideration because of the PhD, and you will not be eligible for another 2 marks or 3 marks against that PhD degree. PhD degree will not be considered twice. In short, if that is the case, then the API score provided by the regulation, which says that 50% marks should be given for good academic records and research performance, then Milot, it becomes a little bit contradictory.
Where is that API score? Where do I get it?
That regulation should Lordship will find.
API score is given there.
Yes, that there's a table appendix, Milot. A bit technical thing, Milot.
I think I just remember today when we are taking up PhD matter.
Yes,
Mr. Sharma, I congratulate you. You have completed your PhD.
not completed. A little bit work is pending.
Work is pending till.
Still,
But somebody told me that you have completed PhD. No.
I got gold medal in masters. That was perhaps what somebody else said.
Okay.
I am doing research under Dr. Gohan sir.
Huh.
A bit
Okay. Somebody told me that you have completed.
6 months
Left.
or 6 months more.
Okay.
It may require.
The chart is in appendix.
I'm coming to the chart. That appendix is appendix 3, table 2C. Today, actually, I'm handicapped because I left my regulation book at home.
Appendix 3.
Appendix 3, Roman 3, table 2, small c. That is the API score, the guidance for the selection committee. As your lordship got.
I think small c is again at typing error. It should be capital C.
Maybe.
Your table 2A.
Table 2C.
No, 2A is capital, B is capital, C cannot be small.
Maybe. Minimum scores for APIs for direct.
So collective wisdom has to be challenged at times.
This is why not in respectful submission. This is perhaps clerical ministerial things.
No, whatever, but it's a collective wisdom. You see, when a notification comes, it is vetted by the highest authority.
My point. That somebody has to shoulder the responsibility.
Always see the last row, second row below, selection committee criteria, weight is
300 points.
So the weight is 100 is equal to 100. So without assistant professor equivalent cadres, stage 1, minimum qualification as stipulated in these regulations, academic record and research performance 50%.
So here it was how much in this case? From page 22, what do you find? What is the score here?
Page 23.
Page
Page 22, 22 it starts. Total score, it shows it goes up to 435. First boy goes, first candidate gets 435.47. So I'll presume it should be. I think they are getting out of 700. Where is the advertisement?
Advertisement, what you will find.
advertisement page 17 million,
Page 70.
17. Does not discloses about the total marks. Total marks of a total micro. So as page 24, the marks of Dr. Mukul Sharma is there. Into is the consolidated marks statement. Well, here 7 selectors were there. 7 numbers of
No,
selectors.
now you see, once you are showing me 2017, it lists me to a different problem. You have referred to the advertisement 2007, page 17.
Yes.
Page 17 says UGC regulation 2009.
No, it should be in 2016. It cannot be 2009
So
regulation.
that I don't know, you see.
No, Milord, what they are saying, Milord, as regard MPhil PhD, there are 2 regulations in USD, UGC. Milord. One,
No, you see, I'll tell you, let me complete. You see, if it goes by 2009, then if I remember it correctly, under 2009, there was an exemption of net sled for
yesterday we argued this case. That was declared null by the Supreme Court, even in P. Susila case. Then nobody can give the exemption. Here the confusion
no,
is.
it is the UGC itself who's giving that exemption.
But that was said not by the central government and ratified by the Supreme Court in P. Susila as well. For some particular period, UGC wanted to give a way about waiving of the net sled.
Yes.
And for that, in 451 UGC meetings, they took a resolution in November,
That was
3rd of November or something.
That was turned down in Sushila.
Yes, the P. Susila. That is what I'm saying. P. Susila judgment. And that resolution was sent to the Supreme Court, the central government for ratification. Central government says nothing doing. On that resolution, some cases were filed in the Supreme Court. Supreme Court in P. Susila has been said that even UGC cannot relax the criteria. That is the settled provision. Now here, my lord, this 2009 is as regard the MPhil PhD regulation. The other regulation is 2010. And this is an advertisement of 2016. As such, the 2010 regulation is applicable. That is where your lordship stand.
No, here you see, for the fourth line, having UGC norms with net SLET PhD in accordance with UCG regulation 2009.
Yes, PhD regulation, the PhD degree shall have to in accordance with the regulation 2009. Because there is a separate regulation for MPhil and PhD. This is called 2000. This was came into existence on 10 July 2009.
So let us come to P. Sushila, because here I have it.
Paragraph 9, 10, and 12, I think, I thought.
Because you see, I'm keeping in mind this 2009 regulation, clause 3.3.1. Because it is in 2009 regulation, 3.3.1 says, net SLET set shall have the minimum eligibility condition for recruitment and appointment of assistant professor in universities, colleges, so and so, provided that candidates who are or have been awarded PhD degree in compliance with the university UGC norms of so and so, regulation 2009, shall be exempt from the requirement of minimum eligibility condition of net SLET for recruitment and appointment of an assistant
That is
professor.
there. That is why in the advertisement it is net / SLET / SET / PhD. It means any one of the criteria. That is why it is oblique.
So that means that it's not an alternative. As per your advertisement, it is not an alternative.
No, one it's alternative because it's the slash means or net or
It's not in lieu of. Here it is. You see, there are two ways of looking at it. Number one, if you have net or net SLET or whatever, and you have a PhD, then you get points for both the degrees. Both the qualifications you get marks, right? Now, if it's an alternative, just like you have said here, it is net SLET / PhD. That means one degree is good enough. You can't have net plus PhD or PhD in lieu of net or TET. That is not there.
well, it may go through the 2010 regulation once.
2009 first, 3.3.1.
But the 2009, it is this particular case will not govern by 2009 regulation, because it's 2016 advertisement, it's governed by the 2010 regulation.
No, you see, if there is an advertisement which is a prescription,
Yes.
if by advertisement there is a prescription given, the authority, the persons who are applying will be guided by this, not 2010. Maybe 2010, maybe 2012, whatever is applicable. You may be right. But the fact is that when the advertisement says a particular qualification,
Well, so far I understand, my understanding goes, well, Lordship was also correct, but correct in saying because this particular sentence is erroneous, because maybe they're intended to mean 2009 PhD regulation. So far as the PhD is concerned.
no, that can't be presumed unless you bring it on record something more.
Because the requisite qualification is enshrined in the 2010 regulation only.
But then you have to take a stand. And UGC can't take UGC will have to take a stand that this advertisement itself was erroneous, so far as your view is there.
Yes, Milord, because this 2009 they are mentioning, this is as regard the word PhD only. Because in 2009 there is no regulation setting for the
No.
requisite criteria.
No, it says UGC norms with net slate PhD within bracket in accordance with UGC regulation.
Lordship is correct in understanding that, Milord. There is no point of misunderstanding. As far as this particular advertisement is concerned, what Lordship has come from your Lordship, Milord, is 110% correct. But actually, it should not have been like this.
So you have to take a stand.
It should have been, the norms should have been as per the 2010 regulation and PhD as per the 2009 regulation. Because what happened, Milord, prior to 2009 regulation came into place, everybody took MPhil and PhD degree through distance mode. And they got the jobs, they got the promotions, higher pay of scale, higher scale of pays, all these things. Now that is why 2009 regulations came into place. Because there is no regulations in 2009 governing the field of required qualifications and all.
Okay. Because this 2009 regulation says no university shall conduct MPhil or PhD through distant mode.
After 10 July 2009, no MPhil PhD through distance mode.
Because if that is your argument, then you have to bring it on record. Otherwise,
Well, it will give me some time. I'll bring everything, all these things I'll clarify.
because if it goes by 2009, then I think
No, what Lordship has understood by reading, very literal meaning is correct what your Lordship is saying. 200% correct. Literally. But actually, this is a mistake.
but we are learning at the cost of Mr. Ganguly.
He has to wait for some more days, Milord.
Mr. A. Ganguly, the counsel for the petitioner. Mr. A. Samar, I'm standing counsel for the UGC, and Mr. S. Mukhtar, I'm counsel appearing for respond number
4.
That is college.
College.
4. Next part. The learned standing counsel for UGC. You are also there for higher education.
Yes, sir.
Mr. M. Das, learned counsel for higher education department. The learned standing counsel for the UGC has submitted that he is of the opinion that an additional affidavit is required to be filed by the UGC. No, you have filed your affidavit, no?
No, Milord, I
Submit that in view of the nature of dispute raised as a petition. The UGC is required to file an affidavit to bring on record. They understand. It is noted with concern that this petition is the petition which was filed on 27th, 2017. And though the UGC has been implemented by order dated 21/4/2017. They have not filed their affidavit in opposition till date. Reluctantly, the matter stands adjourned today. By making it clear that no adjournment shall be granted in this case on the next date. The UGC they'll file their affidavit in opposition. Positively. By 21/4/2023. This is matter for hearing on 27/4/2023. 27/4 for hearing affidavit by 21.
My lord. And hearing is on 27, my lord.
Yes.
If Lordship, I need to controvert anything which I learned from being on record.
Okay. Get 27 now. Reply affidavit if any by the petitioner within a week thereafter. This is a matter for hearing on 11/5/2023.
11.
Published. Right. So Nukta, you also try to find out the marking pattern, how it was given. This 437 or odd. I think every teacher would have been, every invigilator would have given 100 marks. It is 700 out of 437 out of 700. Is that so?
It should be valid.
Just try to get the clarification.
There are individual statement from Mark also. And the consolidated. It shows that 7 people, 7 selectors, 700 marks.
No, but if you are saying, what I've understood from you, if the API score is 300, then whether it is permissible to have the score level at 100.
I'll clarify. This also I'll clarify. Because for oral viva voce, how much marks should be given, how much marks should be allotted in viva voce, that is also enshrined here. I'll clarify. Because from above that particular allotment, they cannot have 10 selectors to give 1,000 marks.
Just have the clarification.
Well, I'm not sure, sir. Obliged.
Item number 7.
Here, from what I have been informed by the department, the school, the petition was filed at a stage when it was yet to be provincialized. Allegation was that there was a misappropriation of the funds that were coming to the school. The BO has given a letter today to the director also that there was no financial aid granted to the school. After provincialization, the persons who have been provincialized are getting their salaries as per the provincialization order, which is not in the challenge of this petition. Those that filed that entire record is on the way. So, because that order also did not specify very clearly as to what therefore I had to prove it. Now, what they tell me is that financial aid was not granted to the school at any point of time, and the salary is being paid to the provincialized teachers as per the provincialization order. Given some more time, the person with the file is coming up. He's on his way from Kailipara.
I'm able to reach because I have to rise at in 10 minutes time.
I understand.
There's a meeting at 3:45.
Lordship permits me, my lord, the record which says that the letter from the block which says that there was no financial grant to the then unprovincialized school and the provincialization order. If Lordship permits, I'll file by way of an affidavit within the next week, certified by the head of by the director of secondary education. That would suffice the production of records.
Do it.
Not so much.
But records you retain.
My lord?
Records you retain because
Yes.
there's already a judicial order for the records. You retain the records. We take up the matter on 2nd.
Only one aspect that has also been taken into account by the petitioner who says that he was the then headmaster when in the original school. Somehow the age comes up to be around 16 years when he becomes the headmaster. How that claim is being made. This might be a litigation which is just prolonging for no reason.
Okay, file it by next,
I'll file it.
you'll file it by when?
Lordship would like to fix it, I'll file it 3 days prior to that.
We can have it on 3rd
Third.
April.
I'll file it by the 30th or 31st, my lord.
You write S Zaman. That's the. Mr. S Zaman, then counsel for the petitioner. Petitioners. Mr. R. Mozinder and Mr. Nichols for the Secondary Education Department submits that the record is called for is on the way and he's likely to receive it within some time. He also pays for, and is granted time till 31/3/2023 to file the affidavit in opposition. This is the matter on 3/4/2023. And you already know these two points you'll have to,
My lord.
these 2 points you'll have to clarify.
Yes.
I'll not be taking up any other part 2 matters today. I'll be rising.